This is going to be a slightly different video because I plan to go through the legal timeline of the case between the Department of Justice suing Google for anti-competitive practices. So I want to explain what's happening, how it's happening, why it's happening, what the potential outcomes of it happening are, and also the potential repercussions of those potential outcomes. And to talk about all of that, we have to start with the lawsuit itself. Here is the press release for it from October 20th of 2020. This is the original suit. Justice Department sues Monopolist Google for violating antitrust laws. Department files complaint against Google to restore competition in search and search advertising markets. Today, the Department of Justice, along with 11 state attorneys general, filed a civil antitrust lawsuit in the U.S. District Court for the District of Columbia to stop Google from unlawfully maintaining monopolies through anti-competitive and exclusionary practices in the search and search advertising markets, and to remedy the competitive harms. The participating state attorneys general offices represent, and then it gives the 11 states. A quick note here is that monopolies themselves are not illegal. What is illegal is using anti-competitive practices to maintain your monopoly, and this might include things like buying out all of your competition or paying companies to use your services exclusively, thus essentially forcing their customers to use your services. And these are both things that Google has done and that the DOJ is going after them for. Here's some more specifics on what the DOJ believes that Google has done wrong. Entering into exclusivity agreements that forbid pre-installation of any competing search service, entering into tying and other arrangements that force pre-installation of its search application in prime location on mobile devices and make them undeletable regardless of consumer preference, entering into long-term agreements with Apple that require Google to be the default and de facto exclusive general search engine in Apple's popular Safari browser and other Apple search tools, and finally, generally using monopoly profits to buy preferential treatment from its search engine on devices, web browsers, and other search access points, creating a continuous and self-reinforcing cycle of monopolization. So at a high level, the Department of Justice is saying that Google is buying their popularity essentially via these large companies like Apple, as opposed to earning it by being the best search engine that there is. The DOJ is saying that customers aren't actually actively choosing Google so much as Google has forced itself into every facet of their lives via the billions and billions of dollars that they have at their disposal, and as a result of that, customers are essentially forced to go with Google. So this, like I said, was published on October 20th of 2020. So we're looking at just over 4 years to date. And you have to understand that huge trials like this take years and sometimes even decades. And there are huge gaps between court appearances because of how complicated these whole affairs are. Everything in a trial as large and significant as this takes a really long time. The investigation's discovery, expert testimony, evidence gathering, and the fact that Google is fighting this absolutely every step of the way, trying to delay it. And for that reason, everything from 2020, when this was initially filed, until 2023, basically nothing happened. It was filed, and then this entire time was spent on the initial part of the trial without anything happening for the next 3 years. So finally, after 3 years of pre-trial, we get to the actual meat and potatoes of a court case, the trial itself, and that took place in 2023 and is summarized here by NBC News. In opening statements Tuesday, the DOJ argued that Google started illegally maintaining a monopoly in its search engine space as early as 2010, according to Reuters. The DOJ's case, which is joined by 11 state attorneys general, argued that Google's closed off competition by securing exclusive deals with major tech platforms, including Apple's iPhone and web browsers like Safari, or via its owned and operated properties like the Google Chrome web browser, according to its initial complaint filed in October of 2020. Defaults are powerful. Scale matters, says Kenneth Somebody, who is spearheading the DOJ's case on this trial, according to Reuters. The DOJ claimed the tech giant spends more than $10 billion annually to situate itself as the default search engine on devices, the Associated Press reported. Google's contracts ensure that rivals cannot match the search quality ad monetization, especially on phones, Dinser says, according to the AP. So the Department of Justice is alleging that Google has spent most of its time and resources trying to make sure that consumers like you and me who use the internet don't even see any other web browsers or any other search engines. They're alleging that instead of making products better, they're trying to buy exclusivity from large companies to make sure consumers like me are trapped in the cycle of only using Google for everything. It's like if Walmart only carried Nike shoes because Nike paid them billions of dollars to kick out all of the other shoes in the store. Probably people would just go ahead and buy Nikes because they work reasonably well, and basically every other shoe manufacturer would see huge dip in sales. Google is paying for two things. They are paying for people's attention, and they are paying to keep other search engines out of the spotlight in a way away from people's attention, with the idea being that if you only ever see Google out and about, then you'll only ever think to use Google when you need a search engine, and that makes Google money. And specifically, the DOJ is alleging that Google spends about $10 billion per year to be the default search engine on Apple phones and also the default search engine for other carriers like Verizon on their phones. So that's what the DOJ is alleging, but Google, for their part, is predictably disagreeing, and they are saying this. Google, on the other hand, says its search dominance is a result of success in market competition. The tech giant's lead attorney on the case, John somebody, argued Tuesday that Google's defeated its competitor Bing at every critical juncture, according to the AP. The lawyer spotlighted the abundance of options available to consumers today in a few easy clicks when looking up information, according to Reuters, arguing that Google's dominance is a reflection of consumer choice in the market. So Google is disagreeing with the DOJ, saying that people can use whatever they want and they are actively choosing to use Google. If they wanted to, they could go out and use another browser. Bing is on every computer, DuckDuckGo is available for download, etc., etc. But Google is arguing that people want to use Google because Google is the best there is. Before we get to the next part of the trial, if you like this kind of deep dive into news, I post 1 to 2 times a week and I'd love a subscription. So everything I just mentioned with both sides giving statements happened in September of 2023. And then after that, there was a huge waiting period until August of 2024, when the DOJ got a small win because a judge ruled in their favor, saying that Google had paid off companies to illegally maintain a search monopoly. In a landmark decision in August of 2024, a DC federal district court ruled that Google had violated federal antitrust laws by illegally maintaining monopoly in online search and search text ads. At issue now are the remedies the court will impose to end Google's improper conduct that has stifled competition and harmed consumers, and the necessary steps to restore competition for the benefit of consumers. It being ruled a monopoly is only the first step. Now you have to decide what to do about that monopoly. Now, the obvious and easiest solution here is to make Google divest some of the individual parts of what makes up Google, such as Gmail or YouTube or the Chrome browser or so on. Any individual thing that Google owns, force that to be sold away as its own company, with the idea being that as its own company, it would have its own advertising business and Google would no longer have a monopoly. And this is basically what the Department of Justice has proposed, along with some other things. Google must promptly and fully divest Chrome to a buyer approved by the plaintiffs, which is the Department of Justice, in their sole discretion, subject to the terms that the court and the plaintiffs approved, the Justice Department said in its proposed final judgment. The Justice Department prosecutors said in the filing that they are also seeking for the court to require Google to stop favoring its own services in its popular Android mobile operating system, or to be forced off to sell Android as well. Prosecutors requested a long list of other measures designed to break Google's search monopoly, including forbidding the company from paying device makers such as Apple to make Google search the default search engine, requiring Google to share its search index with rivals at a low cost, and providing online publishers with easy opt-out from their content being used by Google to train AI models. And this is currently where we are now. This is the most recent news as of today for what's happening with this case. And even though it doesn't seem like very much, this is a large amount of work that's gotten done in a relatively short amount of time, even though 4 years is a long time. These proposed measures will be ruled on by the judge in August of 2025, which of course begs the question, well, what happens until then? And it's kind of hard to say, because Google's plan was obviously to try and delay things until the election in hopes that Trump would be elected and the new administration would be more big tech friendly. And now that Trump has won, we can expect Google's CEO to try and warm up to the new administration and try and get them involved in this case in some measure so that Google isn't broken up. But let's say Google is broken up. What kind of impacts would that have? And it would actually be pretty good, I think. There would be more search competition, which might mean fewer ads for you, and it would also mean cheaper ads for marketers as competition would increase. It would also set a huge legal precedent and would probably empower the Department of Justice to go after other monopolies like Amazon and Facebook, claiming that they have similar anti-competitive practices going on. Now, to be clear, it's going to be a while before we find out what happens. August 2025 is the soonest, but probably something will be appealed or changed or rejected and will be delayed into 2026 sometimes. But it's also important to remember that breaking up monopolies is really important. Even if you like Google, which to be fair, I do, competition breeds innovation, and search has barely changed in the last 10 years or so. And that's because nobody can compete with Google because of how much money Google has. So why would Google bother spending money to change things when it can spend money to keep things how they are and keep making a bunch of money? This breakup would definitely be a net good for consumers like us and also marketers. Thanks for watching.